Good morning, Kakistan! Come now and listen to my never-ending quest to make Kenda a better place by making bureaucrats look like complete morons. Wow! We're gonna start this series and New Year out with a bang. I couldn't have handpicked this request better myself, because it will really set the tone of the rest of the series. To be honest, this is the only request the CNSC has given me back so far. Let me back up a bit. I have filed access to information requests with the Canadian government. I am going to document my findings here with you, my legion of fans in the double digits. Now, my motivation behind this request was that a few years ago, the CNSC had given a directive to all licensees that they were going to exercise their regulatory authority over accelerators down to 1 MeV. Now, being a scholar of nuclear engineering and very interested in the law, I know the CNSC is on some pretty shaky ground right there. Sorry, folks. This is going to get ridiculously technical, both in law and physics. The constitutional jurisdiction of the federal government is atomic energy, as found in the Supreme Court ruling of Ontario Hydro versus Ontario. This is because, and I quote the ruling, "It is predominantly extraprovincial and international in character and implications, and possesses sufficiently distinct and separate characteristics to make it subject to Parliament's residual power. The strategic and security aspects of nuclear power in relation to national defense and the catastrophe and near catastrophe associated with the peaceful use and development at Chernobyl and 3 Mile Island bespeak its national character and uniqueness." Now, the problem here is the court found atomic energy unique because its character is interprovincial. This is a problem here for the CNSC opinion that they may regulate nuclear energy as found in the Nuclear Safety Control Act. I'm going to prove that these accelerators cannot be put in the same regulatory category as nuclear reactors or uranium mines. You see, jurisdiction of property was granted to the provinces in the Canadian Constitution, and only the provinces may make laws in relation to matters of property and civil rights. Let's take a look at low-power accelerators that you might know of already, but they go by a different name. X-ray devices. So an X-ray device is a cathode ray tube, cathode ray gun, like your old TV, that accelerates electrons, like your old TV, to hit a tungsten target, not like your old TV, to produce X-rays. X-rays are non-nuclear in nature. They have no nuclear component, and in this case, the X-rays are produced when the cathode rays, the electrons, are slowed down rapidly. There's no nuclear process going on, nothing nuclear. Because these things are non-nuclear, but mostly because they're property, the province has jurisdiction on these devices. This is the status quo. This is how things are right now. I asked myself, how is a 1 MeV accelerator any different than an X-ray device that the CNSC think they can regulate one but not the other? That is the setting of the stage for my request. So I requested to the CNSC, and I quote, "Provide any records describing the technical and legal basis that grants the CNSC the ability to regulate electron particle accelerators operating at or above 1.5 MeV, and any records describing the technical and legal basis that grants the CNSC the ability to regulate electron particle accelerators operating at or above 1 MeV for ease of application, as described in EDOC, their document," end quote. They sent me back a few documents that were really helpful. I was stunned that these documents actually answered the request. Oh, they blanked out sections because it had to do with federal, provincial consultations and deliberations, or advice and recommendations. The CNSC staff start off saying this is a problem of ambiguity, and they will fix it with more regulations. They're going to fix it with more regulations. How nice of them. However, where did this 1 MeV come from again? Well, turns out the 1.5 MeV was derived according to their documents, because if you hit a lithium target with a 1.5 MeV photon, you'll get a nuclear reaction. Why is this important? The Nuclear Safety and Control Act says that all nuclear reactions are under their jurisdiction, under the federal jurisdiction. Then they decided, oh, we'll just round down to 1 to make us happy. There are a few problems with this. Let's unpack it. First, this only applies if the target material is lithium, that the thing you're hitting with your accelerator is lithium. Therefore, the regulation should only apply where the operator of the accelerator is using lithium as the target, or has lithium in the target. I can imagine this is fairly rare. To regulate all accelerators based on the potential at 1.5 MeV would smell pretty fishy to any judge about constitutional jurisdiction. Parliament cannot sculpt jurisdiction on only a small, probably non-existent subset. This is what they're claiming to do. Second of all, there's a problem with the science involved. The number 1.5 is actually 1.47 MeV. I know this because I had to work backwards from how they got it. They just gave me the lithium reaction and said this can happen at 1.47 MeV. But what this means is lithium is undergoing photodisintegration. So what they did was they took lithium-6, I didn't mention that part, it has to be lithium-6, and they found the minimum energy that it would take to pry off a deuteron. So the math works out, as seen here, but the physics doesn't work out. Just because something's possible doesn't make it likely. The best data for this particular reaction shows that scientists can't even detect the reaction below 5 MeV. Citation below. The reason for this is the fact that while the nuclear reaction might have occurred, the energy the deuteron would have would be exactly 0 at 1.47 MeV. This is the minimum energy to split off the deuteron, and by definition does not impart dangerous radiation to the deuteron. This is a fairly big difference. Even if the physicists could detect the nuclear interaction, the probability of this interaction even occurring while non-zero is incalculably low at 1.47 MeV. Even if we ramped up the energy to, say, 7 MeV or so, the radiation given off in such an interaction would be absorbed in less than 0.01 millimeters of the lithium that you're hitting. What this means is that even if the radiation was created, it would be absorbed by the target itself, what you're hitting. So in summary, even if the operator is using a lithium target, the reaction is almost impossible. Even if the reaction does happen, the radiation won't even make it out of lithium. So that explains in great detail how the CNSC staff are misrepresenting nuclear physics. Now the other part of this video explains in great detail that CNSC don't understand constitutional law either. I'm putting forth the theory that large sections of the Nuclear Safety Control Act is ultra vires, or outside of the bounds of Parliament to enact. There are only two ways the federal government, and hence the CNSC, can regulate nuclear energy. Under Section 91 of the Constitution, the Peace, Order, and Good Governance Clause, where the Crown Zellerbach ruling has definitive, and under section 9210C, where the work must be declared by Parliament of Canada to be for the general advantage of Canada. So let's look at this general advantage of Canada line. This has been twice held to be true for uranium mines in Ontario, that they are subject to federal jurisdiction because mining of uranium is essential to the national interest to control and supervise atomic energy, and also to enable Canada to participate in the measures for international control of that energy." End quote. This is a problem for accelerators and really all Class 2 devices, as accelerators neither have international nor general advantage of Canada. It is completely obvious that Parliament has decided to use the 9210C clause enacting the Nuclear Safety Control Act. They specifically state in the Act, and I quote, "It is essential in the national and international interests to regulate the development, production, and use of nuclear energy and the production, possession, and use of nuclear substances, prescribed equipment, and prescribed information." End quote. The jurisdiction of the federal government, and therefore the CNSC, is limited to atomic energy as found by the Supreme Court Supra. In Ontario Hydro Supra, the court found that the federal government's jurisdiction, and I quote, "over a declared work must be limited so as to respect the powers of the provincial legislatures, but consistent with the appropriate recognition of the federal interests involved." End quote. I lay the case that they have exceeded this in the case of regulating accelerators and all Class 2 devices. Furthermore, just because something is possible doesn't mean that the CNSC has the right to regulate it. If we follow this logic, the CNSC would have the right to regulate high voltage transmission lines in excess of 1.47 megavolts. This is a logical continuance of the argument made above. Since it is possible for high voltage electricity to cause a nuclear reaction, the federal government, via the CNSC, would be able to regulate it. The Supreme Court would not accept such an intrusion into provincial jurisdiction, but this is exactly what the CNSC has done with these accelerators. So what does this mean? Well, nothing for most of us. However, if you're a person with an accelerator or a small quantity of nuclear substance, it means you're being regulated by their own government. What can you do about it? Well, under common law, every person has the right to have the decision of an administrative decision maker, like the CNSC, reviewed by the court. Therefore, if you have a license from the CNSC and has nothing to do with national safety, I encourage you to file a request with the Section 96 court to review the correctness of the constitutional jurisdiction of the license requirements placed on you by the CNSC. However, I want to make Canada a better place too. Therefore, in the next few days, I will be mailing letters to each provincial government and radiation safety bodies detailing what I have shared with you today. If they want to do something with this information, it is up to them. Well done! You made it to the end. I'm proud of you. Praise Keck.